Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Izzah binti Abdul Manas. So today I will present on the topic breach of statutory duty. So for the question number two, there was a man named Aznan that was driving his car along the Jalan Kuching Kuala Lumpur towards his office, and suddenly there was a big tree collapsed and crushed his car. So as a result of the accident, Aznan suffered serious injuries and is now paralyzed from neck and down, and his car was badly damaged. So the tree was very big that was covered all the four lanes of the highway, and now Aznan want to take the legal action against the DBKL, the Dewan Bandaraya Kuala Lumpur, for breach of the statutory duties. Section 101 paragraph B and C of the Local Government Act 1976. Basically, under this section 101, it stated that the local authority shall have the power to plant, to trim, or to remove the trees that was alongside, beside the road or the street. Azanan claims that it was the duty of the DBKL to ensure that all the trees along the said road were properly trimmed and also to remove when they pose a danger to the public. But however, DBKL contends that Azanan did not show that the precise location of the tree, hence it could not be said that the tree was posed danger to the public. So now, who DBKL will be liable for breach of statutory duty? For the first issue, the issue is whether the DBKL will be liable for breach of statutory duty under Section 101, paragraph B and C of the Local Government Act 1976, which caused serious injury towards Aznan and damage of his car. So, as we learned before this, there is five elements breach of statutory duties that must be fulfilled for the claimant to succeed his claim. For the first element, the statute allows a cause of action in tort. In the case of Tohmude Wahab and Peter Bridge, the facts that the defendant was breached the duty to fence mining land, which is under Section 81 of the Mining Enactment 1904. The plaintiff's elephant strayed on the mining land, and one fell down the unfenced mining pit. The court held that there is no action could lie for injuries sustained through the non-performance of a statutory duty when penalties for non-performance were provided for under the statute. To establish the right of action, the cause of injury per se must be an actionable wrong, independent of the statute. For the second element, the defendant must be in breach of his statutory duty. In the case of UDA Holding Berhad and Pasaraya Malaysia Berhad, the facts that the Section 46, subsection 4 of Street, Drainage and Building Act empowers the local authority to allow temporary erections for purposes of festivals and ceremonies and not for the purpose of which LHH3 was in fact closed. So the court held that in this case, there is no positive obligations was established on the part of UDA Holdings based on the statute. So the UDA Holdings was not breach of his statutory duties, and it was not stated in the statute, and it was differently in this case. The DBKL was breached their statutory duty because it was clearly stated under Section 101 of the Local Government Act that the local government, the local authority shall trim all the trees that was pose danger to the public. For the third element, a duty must be owed to the plaintiff. In the case of Lim Ting Eng and Sungai Voh Rubber, the facts that machine must be installed in a specific manner to prevent the hands of the operator from having contact with the machines for to suffer the and suffered injuries. So the court held that the plaintiff fell under the class of protected persons. It means that the means of a duty must be owed to the plaintiff. It means that the plaintiff must prove he is a member of the class of persons that was protected under statute. And it was similarly in this case that the Azlan was a public person and he was protected under the section 101 paragraph B and also C of the Local Government Act 1976. For the fourth element, The statutory breach must have caused the damage. In the case of Gan Kim Tai and the Union Omnibus, the facts that the plaintiff sued the defendant for causing the stroke and made his paralyzed due to overwork. The court held that there was no breach at all because the plaintiff itself overworked and not because of the defendant. But however, it was different in this case. Azlan suffered the paralysis from his neck down, and his car also damaged because of the tree, because and also the DBKL was failed to remove the tree that was posed danger to the public, and the DBKL was breached the statutory duty under the section 101 paragraph B and C of the Local Government Act 1976. For the last elements, the injury or damage must be of the kind which the statute is intended to prevent. So in the case of Goris and Scott, the facts that statutory duty was to provide pens of specified size for the carriage of animals on his which is defendant's ship, and then the plaintiff's ship was swept overboard. The court held that the damage was not intended to prevent by the statute as it was to prevent disease, not to prevent animals from drowning to the sea. And it was differently in the present case. Under the section 101, the paragraph C, it states that the local authority is likely to endanger the public safety or inconvenience, and in the event of any tree situated in private premises. It means that the local authority shall have the power to trim the tree that was posed danger or endanger to the public and can cause the damage or the inconvenience to the public. For the application, in the present case, the facts that the tree was collapsed and also covered all the four lanes of the highway, which was situated at a public place. The tree posed a danger to the public, and the accident happened after a thunderstorm. The Local Government Act 1976 established DBKL's general responsibility for public welfare by granting them the authority to manage trees that may endanger public safety. This statutory duty implies a duty of care to prevent foreseeable hazards, such as collapse or dangerously positioned tree. So by failing to exercise the reasonable care in maintaining the tree, to trim, to remove the tree, which directly led to Azlan, which is a public person, serious injuries. DBKL breached this duty. So this breach will allow Azlan to pursue a cause of action as the statute intends to protect public safety, which hold the DBKLs liable for negligence in fulfilling their statutory duties. So this is one of the similar case, which is the case of Ahmad Jafar Abdul Latif and Datuk Bandar Kuala Lumpur. But however, in this case, the appellant was failed to prove his case on the balance of probability because he failed to establish that the tree was posed danger to the public before the accident occurred. So the federal court in this case held that the location of the trees is of primary importance since the federal court cannot make a finding of fact that the tree was posed or endangered to the public when there is insufficient evidence as to precise the location of the tree. And the powers that was conferred on the local authorities such as the respondent, Datuk Bandar Kuala Lumpur, under Section 101B and C of the Act is subject to the element danger being present and proven based on reading to the same sections. So in this case, the appeal that was brought by the Ahmad Jafar Abdul Latif was dismissed. So as we see before this, five elements for breach of statutory duty were fulfilled. So for the conclusion, Azlan can sue DBKL for breach of statutory duty as DBKL failed to fulfill their responsibilities and obligations to trim the trees that was posed danger to the public under Section 101, paragraph B and C of the Local Government Act 1976. The tree was collapsed and causing a serious injury towards Azlan and his property damage. Azlan was a member of public that used the public road. He falls within the class of persons the statute intended to protect. For the defenses, is DBKL can raise his defense in this case. For the first defense, voluntary non-injuria, it means that the claimant, the one that suffered injuries itself, he itself volunteered for the injuries. So, for in the case of Muhammad Hussein and Shum Yip Leong, the facts that the plaintiff co-worker carelessly knocked down the equipment that was meant to cut the rubber sheets into tiny pieces and caused the plaintiff to suffer the severe injuries to his right hand. So it says that the defendant was violated the machinery regulations by failing to install or to supply a guard to keep an operator's finger out of the danger zone. But however, in this case, the court held that the primary reason for the accident was determined to the employer's violation of their statutory obligations. If the plaintiff itself was volunteer for the injuries, the defendant will not be liable for it. Secondly, contributory negligence. In the case of Wong Sun San and Malayan United Industrial Co. Limited, the facts that the defendant's employers failed to provide the goggles or the face shields to their machine operators. So the court held that the defendant has breached their statutory duty, but however, due to the plaintiff contributory negligence, meaning that the plaintiff itself not taking the precautions, so the sum of the claim for the damages will be reduced. For the conclusions, can DBKL raise their defense? No, the DBKL was unable and it was very hard for the DBKL to raise their defense for their action. It violated and breaching the statutory duty under Section 101, paragraph B and also C of the Local Government Act 1976, as the accident was unforeseeable by Azlan, and so the tree was posed danger to the public, and the tree itself it was beside the road. And Azlan cannot voluntarily assume the risk of a tree collapse and also falling on his car. And additionally, DBKL was unable to demonstrate Azlan's negligence in contributing to the accident. That's all from me. Thank you and Assalamualaikum warahmatullahi wabarakatuh.